PVL3702, Law of Contract, Chapter 7, Legality. Number 7.1, Introduction. An underlying principle of the law of contract is that agreements seriously entered into should be enforced. This finds expression in the principle of sanctity of contract, the pacta sunt servanda. On the other hand, agreements contrary to public policy will not be enforced. Considerations of public policy indicating that an agreement should not be enforced are to be found in legislation, the common law, good morals, and the public interest. Since 1994, public policy has been anchored primarily in the values enshrined in the Constitution. When an agreement is considered contrary to public policy and unenforceable, in effect, the policy consideration indicating that the agreement should not be enforced is given precedence over the policy consideration that agreements seriously concluded should be enforced. This in turn suggests that the determination of legality or illegality often entails a process of weighing up or balancing of public and private interests. One of the requirements for a valid contract is that the contract has to be legal in principle. The illegality of a contract has two possible consequences. Generally speaking, illegal, unlawful contracts are either void and thus unenforceable, or valid but unenforceable, depending on the degree to which society regards a specific contract as reprehensible. For example, some wages are valid, others are valid but unenforceable, and still others are void. This chapter considers various forms of illegal contracts. Bear in mind, though, that the discussion is not exhaustive, since there are simply too many instances where an agreement may be in conflict with statutory or common law. Only some of the more prominent examples are dealt with here. Agreements are illegal if they are in conflict with common law or statutory law, including the Constitution, in that either the conclusion of an agreement, its performance, or the reason for its conclusion, that is, the object or purpose of the agreement, is contrary to public interest or a statutory prohibition. Number 7.2. Illegal contracts that are void. Contracts may be void for illegality for a variety of reasons. While the overarching consideration is whether the contract is against the public interest, the specific illegality of a contract may be recognized at common law or in statute or simply with reference to certain moral and constitutional values, or even perhaps with reference to the unfair manner in which a contract is enforced. These, together with the consequences of such illegality, are discussed in some detail below. Number 7.2.1. Public interest. The courts often state that a contract is illegal because it is contrary to good morals, that is, contra bonus mores, on the one hand, or public policy on the other. This distinction has little inherent value because the underlying principles very often overlap. Both instances relate to society's view of morality, and in both cases, the contract is regarded as contrary to public policy. In Susvin Proprietary Limited versus Beekes, the appellate division put it as follows: agreements which are clearly inimical to the interests of the community, whether they are contrary to the law or morality or run counter to social or economic expedience, will accordingly, on the grounds of public policy, not be enforced. The interests of the community or society as a whole are of paramount importance in relation to the concept of public policy. In a heterogeneous society such as South Africa, the interests of a section of the population have to be evaluated within the context of society as a whole. Society often has an interest in protecting the interests of its different sections as well as individuals. Individuals and sections of society similarly have an interest in the maintenance of the interests of society as a whole. Recognized public interests include: Number 1. Voluntary concluded contracts should be complied with and enforced. That is the sanctity of contracts. Number 2. Simple justice between individuals should be taken into account. Number 3. As far as possible, the parties to a contract should have equal bargaining power. Number 4. The administration of justice should not be defeated, obstructed, or perverted. Number 5. The safety of the state should be preserved. Number 6. The public service should function properly. And lastly, the full exercise by persons of their legal rights should not be interfered with. Public policy has no fixed meaning because it represents the public opinion of a particular community at a particular time. This concept can thus vary in content from society to society and from time to time. Public policy is therefore an open-ended standard. At first glance, the exercise of the power to declare a contract contrary to public policy seems to be a difficult and contentious task, but public policy is not as problematic as it initially appears to be, for the reasons set out below. Number 1. The courts use their power to strike down a contract for being contrary to public policy sparingly and only in the clearest of cases. The impropriety of the transaction and the elements of public harm must be manifest. Two reasons can be advanced for such an approach. The first is that an arbitrary or indiscriminate use of this competence will undermine certainty and security in contractual relations. The second is that the principle of sanctity of contract is usually afforded preference over other public interests. Number 2. The courts will declare a contract illegal if they consider the tendency of the contract and not its actual proven result to be against public policy. If the contract is capable of being implemented in a manner that is against public policy, but the tendency is neutral, the contract will be valid. Number 3. The courts will be careful not to conclude that a contract is contrary to public policy simply because it offends the court's individual sense of propriety and fairness. Number 4. Since the inception of South Africa's constitutional dispensation of 1994, public policy is primarily rooted in the Constitution and values enshrined particularly in the Bill of Rights. But it is not the sole source of public policy. The Bill of Rights of both the 1994 and 1996 constitutions entrenched many public interests that are already recognized as such by our common law. Number 5. Legal precedents therefore provide guidelines as to whether a particular contract or term is contrary to public policy. There are, however, two caveats attached to the use of case law. Firstly, case law before 1994 should be tested against entrenched constitutional values, and secondly, it should be borne in mind that public policy on a particular issue could have changed in the meantime. And then there's a small pause for reflection. What is the correct approach to a contractual term that potentially conflicts with a constitutional provision? Recently, in Barkhuizen versus Napier, the Constitutional Court discussed the question whether the validity of a contractual term can be directly tested against a provision of the Bill of Rights. The majority seriously doubted the appropriateness of such an approach because of two insurmountable obstacles related to the fact that a contractual term is neither a law of general application nor conduct. The first difficulty is that a contractual term cannot be subjected to a limitation analysis under Section 36, subsection 1 of the Constitution, as this section only applies to a law of general application. The second difficulty is that Section 172, subsection 1a of the Constitution cannot apply to contractual terms as this section requires a court to declare a law or conduct inconsistent with the Constitution as invalid. The correct approach to a constitutional challenge to a contractual term, therefore, is to determine whether the term of the contract is contrary to public policy. The majority of the court stated, this leaves space for the doctrine of pacta sunt servanda to operate, but at the same time allows courts to decline to enforce contractual terms that are in conflict with constitutional values, even though the parties may have consented to them. That's the end of the pause for reflection. A court will consider all relevant public interests in deciding whether a specific contract is against public policy. When the interests are of rival or even conflicting nature, a court will balance the different interests. Preference is shown to sanctity of contract in this regard. In the pre-constitutional state, freedom of contract and consequently sanctity of contract were given preference above other public interests. This preference explains the restraint that the courts have shown when declaring a contract or clause contrary to public policy, and the preference prevailed when South Africa became a constitutional state in 1994. Such an approach is underscored by the constitutional values of dignity, equality, and freedom. Recently, in Barkhuizen versus Napier, the Constitutional Court, by implication, approved of the preference displayed towards sanctity of contract by adhering to the traditional approach. Self-autonomy, which includes contractual autonomy or the ability to regulate one's own affairs, even to one's own detriment, is the very essence of freedom and also informs the constitutional value of dignity. The constitutional value of freedom of contract includes the principle of sanctity of contract and informs a number of other constitutional rights. However, the inequality of bargaining power between parties is an important factor that reduces the weight that should be attached to the values of freedom and dignity. Freedom of contract finds its limit where, instead of enhancing, it diminishes the self-respect and dignity of the parties. The countervailing public interests or interest then trumps sanctity of contract. A party who wishes to rely on illegality should plead it, and the onus to prove it also rests on him or her. However, a court will, of its own accord, take notice of the illegality of a contract and regard the contract as against public policy, even though the defendant does not raise the issue of illegality or even if the parties wish to waive it. The prerequisite is that the illegality must appear from the contract itself or from unambiguous evidence of the illegality of the contract that is before the court. Number 7.2.2. The conclusion, performance, and object of the contract must be lawful. Some contracts are void because the mere conclusion of the contract is contrary to a statutory provision, good morals, or public policy. The following are examples. Number 1. Contracts that are void on the basis of statutory prohibitions. Number 2. Certain pacta successoria. Number 3. Contracts with enemy subjects. And lastly, certain agreements that ousts the jurisdiction of the courts. Certain summary execution clauses, parate executi, and conclusive proof clauses are examples of agreements that oust the jurisdiction of the courts. A conclusive proof clause that is a clause that provides that a certificate of balance constitutes conclusive proof of the indebtedness of the debtor. If the author of such a certificate is the creditor, the clause will be against public policy and therefore invalid, because it makes the creditor the judge in his or her own cause. The same objection does not arise where the author of the certificate is an independent third person. The clause will then be valid. The performance of the contract must be legal. Examples of contracts with illegal performances are contracts to commit a crime, such as murder or robbery or a delict. Where a contract can be carried out in a lawful as well as an unlawful manner, the presumption is that the parties intended the contract to be carried out in a lawful manner. The purpose or object of the contract must also be lawful. The purpose of a contract will only be illegal if both parties have the same illegal purpose in mind. If one of the parties is not aware of the other's illegal motive, the contract does not have an illegal purpose, but the innocent party may validly refuse to perform his or her obligations because of the illegal purpose of the other party. A case illustrating the application of this principle is Kennedy versus Steenkamp. K and S agreed to purchase uncut diamonds illegally for the price of £400. S gave K a promissory note to cover his share in the illicit transaction. S raised the defense that the promissory note was given for an illegal purpose, but K raised an exception to this plea. The court held that S had raised a valid defense because the promissory note's causa was unlawful. The promissory note was a separate contract and its purpose, namely to cover S's share in the illegal contract, was likewise illegal. Similarly, a contract between an insolvent debtor and one of his or her creditors illegally to grant that creditor preference above the debtor's other creditors is illegal. Number 7.2.3. Specific examples of illegal contracts that are void. Different types of illegal contracts may be identified and warrant further discussion. The illegality may arise from a variety of sources. Number 7.2.3.1. Contracts against good morals. Although the distinction between agreements contrary to good morals and those against public policy is not valid, examples of the former that have enjoyed recognition are referred to briefly below. An exact definition of what was contrary to good morals remains elusive. Nevertheless, good morals apparently refer to good behavior in the community. In most of the instances where the court held that the performance was contrary to good morals, the conduct involved was immoral or sexually reprehensible, such as an agreement to pay a prostitute for sexual intercourse or the insurance of a brothel. However, conduct against good morals is not limited to instances of sexual immorality. The contract of a divorced father to trade his claim for the custody of his children to their detriment in return for financial reward has been regarded as contrary to good morals, and therefore void. A further example arose in Maseko versus Maseko. The plaintiff, in order to protect her house against possible attachment by one of her creditors, agreed to marry the defendant, transfer the house into his name, and thereafter get divorced. The defendant undertook to retransfer the house back to her after the threat of attachment was over. Although the plaintiff was never insolvent at any stage, the court held that the agreement was illegal on 3 grounds. Firstly, it was morally reprehensible because it was designed to mislead existing or potential creditors as to the plaintiff's worth, even if it had not yet served that purpose. Secondly, the agreement undermined the institution of marriage. And thirdly, it perpetrated fraud against the court in the divorce proceedings. Interestingly, the court remarked that the first reason was both immoral and against public policy, illustrating the close relationship between these concepts. Number 7.2.3.2. Statutory illegality. On occasion, the legislator gives concrete content to public policy by expressly or impliedly prohibiting the conclusion of specific types of contract in general or under certain circumstances. The intention of the legislator is of primary importance in determining whether a contract is void. Clearly, a contract is void where the relevant statutory enactment expressly provides, or where it declares a contract to be of no force or effect. There are many examples of such statutes, such as those relating to the sale of dangerous weapons, firearms, alcohol, drugs, and uncut diamonds. A contract that is aimed at circumventing the provisions of a statute prohibiting an act or contract that is in fraudem legis is also illegal and void. In this regard, Section 19 of the National Credit Act is important. Not only does this provision state that certain clauses in a credit agreement are unlawful, but it also sets out the available remedies. A court may either sever the unlawful provision from the agreement or alter the agreement to the extent required to render it lawful, or declare the entire agreement unlawful as from the date on which the agreement took effect. Section 51 of the Consumer Protection Act similarly prohibits a number of clauses in consumer contracts and states that such clauses are void. Very often, the conclusion of a contract is prohibited by legislation, but the legislator fails to state expressly whether the contract is void if it falls foul of the prohibition. The difficult task then is to determine whether the legislator has impliedly provided for nullity. The particular statute has to be interpreted, and the courts take the cumulative effect of the following factors into consideration in determining whether the legislator impliedly intended the contract to be void. Number 1. What is the object of the statute, and what mischief or harm is the statute directed against? If the validity of the contract brings about the harm the statute is directed against, it is an indication that the legislator intended the contract to be void. Number 2. Does the enactment impose a criminal sanction? This is usually an indication that the legislator intended the contract to be void. However, this is not the case where the sanction provides adequate protection against the mischief that the statute is directed against. And number 3, does the enactment merely serve to protect the revenue of the state? If the answer is in the affirmative, it is an indication that the legislator intended the contract to be valid. Number 4, does the provision merely protect individuals, or does it involve a public interest that requires protection by voiding the contract? If the provision is for the protection of the public, it would be an indication that the legislator intended the contract to be void. And lastly, what are the consequences of a particular interpretation of the contract? A balance of convenience test is employed that questions whether the nullity of the contract would cause greater inconvenience and injustice than allowing the illegal conduct to stand. The above-mentioned approach may be illustrated with reference to certain forms of gambling and betting. The provisions of the National Gambling Act apply. The definition of gambling activity is very wide and includes all forms of wagering and gambling. Primarily, however, gambling activity constitutes wagering and gambling contracts. The Act does not expressly declare any gambling contracts or wagering contracts to be void. Section 8 provides, despite any other law, a person must not engage in, conduct, or make available a gambling activity except 3 exceptions are then listed: licensed gambling activities, social gambling specifically permitted by provincial legislation, and informal bets. However, not all informal bets are excluded from the prohibition. Informal bets require further explanation. An informal bet is described in Section 1 as a bet or wager or agreement between 2 or more persons that provide that: Number 1, none of the parties is a bookmaker or derives a significant portion of his or her livelihood from gambling. And number 2, none of the parties is paid a fee or derives any gain other than winning the bet itself. An informal bet that does not comply with the above 2 limitations is thus prohibited. An informal bet is furthermore prohibited by Section 8 if there are valid grounds to conclude that any of the parties to the bets intended to establish enforceable contractual relationships when they staked or accepted a stake of money in that contingency. Contravention of Section 8 is a crime. A person may not knowingly pay a winning arising from an unlawful gambling activity. Such a payment is prohibited as a crime. However, the acceptance of the payment of a winning is neither prohibited nor a crime. Section 16, subsection 1 provides that a debt incurred in the course of an unlawful gambling activity is not enforceable in law, despite the provisions of the common law or any other law. A wagering or gambling contract is valid but unenforceable at common law. The National Gambling Act also creates a mechanism whereby a winning which may not be paid out is forfeited to the state. The following observations about the legislator's intention in the National Gambling Act may be made based on the considerations discussed above. Number 1. Section 16, subsection 1 merely states that bets arising from unlawful gambling activities are unenforceable and does not expressly state that the wagering contract is void. Number 2. The purpose of the Act is to regulate license, control and police gambling in South Africa as a whole. Section 8 plays a very important role in this regard. All forms of gambling are prohibited except licensed gambling, gambling specifically exempted in terms of legislation, and some forms of informal bet. Unlicensed gambling and some forms of informal bet are prohibited. The purpose of Section 8 is apparently to protect individuals, society, and the economy against the adverse effects of gambling. Section 8 is thus clearly in the public interest. The protection of the revenue of the state is not an aim of this section. Number 3. The prohibition contained in Section 8 is directed against certain wagering contracts, and the conclusion of such contracts is criminalized. If such wagering contracts were regarded as valid but unenforceable, the harm that Section 8 aims to alleviate will in fact occur. And lastly, the performance of unlawful wagering contracts are also attracted to the legislature's attention. Number 1. The paying out of winnings from an unlawful gambling activity knowingly is prohibited as a crime. And secondly, a winning from an unlawful gambling activity can be declared forfeit to the state. Both are indications that the legislature intended unlawful gambling contracts to be void. From the above, it seems that the legislator has implied that wagering contracts arising from unlawful gambling activities are void. Number 7.2.3.3 Pacta de quota litis, champerty and maintenance. A pactum de quota litis is an agreement in terms of which one party will provide funds for litigation by the other party in exchange for a share of the proceeds should the case be successful. Pacta de quota litis were regarded with disfavor in Roman and Roman Dutch law because they were considered to encourage speculative litigation, and this amounted to an abuse of the legal process. Our law was influenced by English law and has even adopted some of its rules. English law distinguishes between two agreements, champertus and maintenance agreements, both of which are illegal and unenforceable. Champertus agreements in English law are similar to our common law pacta de quota litis and fall into the wider category of maintenance agreements. The latter are agreements in which one party improperly assists another party in litigation because the assisting party has no legitimate interest in the litigation and has no just cause or excuse to become involved in the litigation. There was a need to protect the system of civil justice as it was undeveloped and had no independent judiciary. Our courts have held that agreements whereby an outsider provided finance to enable a party to litigate in return for a share of the proceeds of an action, if successful, or any agreement whereby a party was said to traffic, gamble, or speculate in litigation, were invalid. The exception was where the agreement had been concluded in good faith to assist the litigant in the exercise of his or her rights. In order to enable litigants with meager resources to litigate in the courts, the Contingency Fees Act was enacted to allow a legal practitioner, that is, an attorney or advocate, to validly conclude a contingency fee agreement if the practitioner thought that the client had a reasonable prospect of success. Such an agreement can either be in the form of a no-win, no-fee agreement, or may be an agreement that the practitioner will receive more than his or her usual fee if the case is won. All other contingency fee agreements remain illegal. In PricewaterhouseCoopers Incorporated versus National Potato Cooperative Limited, the Supreme Court of Appeal held that a pactum de quota litis is no longer against public policy or void. The court noted that in the civil justice system is now well developed and that civil courts are independent. The Contingency Fees Act indicates a change in public policy as it now allows speculative litigation by endorsing both the no-win, no-fee agreement and an agreement for the sharing of the proceeds of the action. That is, the practitioner will receive more than his or her usual fee if the case is won. The legislator considered that the potential conflict between the duties and interests of the legal practitioners will not lead to an abuse of legal process. Recognition of the need to enable people to take their disputes to court is consistent with the constitutional right to have legal disputes resolved in a fair public hearing before a court, and with freedom of contract. Number 7.2.3.4 Unfair contracts. The individual interests of the parties also play a role in determining whether a contract or clause is against public policy. The necessity of doing simple justice between parties and the need to address inequality of bargaining power between parties are both recognized as public interests. The unfairness or unreasonableness of a contract or clause towards one of the parties, as well as the interest that the other party seeks to protect with the contract, are taken into account. In Barkhuizen versus Napier, the Constitutional Court stated as follows: notions of fairness, justice, and equity and reasonableness cannot be separated from public policy. Public policy takes into account the necessity to do simple justice between individuals. It is informed by the concept of Ubuntu. Although it is clear from the case law that fairness plays a role in determining public policy, it is still unclear exactly what role it plays. The crucial question is whether it can be the only public interest which a court considers when determining whether a clause or contract is against public policy. This also raises the question of what role the principle of good faith plays in determining what is fair and reasonable in a contract. Good faith has been recognized as a fundamental principle that underlies the law of contract and informs its various rules and principles, including those regarding illegality. However, the courts have yet to spell out precisely how good faith informs the rules about illegality. Commentators have suggested that a clear relationship exists between what is in good faith between the negotiating parties and what is fair and reasonable in a specific case. Although good faith may have a subjective or objective meaning, commentators have suggested an objective test. Has the one party so unreasonably and one-sidedly promoted his or her own interests at the expense of the other party that this infringement of the principle of good faith outweighs the public interest in the enforcement of the contract? Before the advent of our constitutional democracy, the Appellate Division held in Susman Proprietary Limited versus Beekes that a contract would be against public policy if so unfair as to be detrimental to the interests of the community. The court warned. The power to declare contracts contrary to public policy should, however, be exercised sparingly and only in the clearest of cases, lest uncertainty as to the validity of contracts result from an arbitrary or indiscriminate use of the power. One must be careful not to conclude that a contract is contrary to public policy merely because its terms, or some of them, offend one's individual sense of propriety and fairness. In this case, two contractual terms gave S, a financier, immediate and effective control of B's income as a doctor. B was furthermore not able to end this situation, only S could. The contract gave protection to S beyond what was reasonably necessary to protect its interests in having security for B's indebtedness. The Appellate Division found that the terms placed B in the position of a virtual slave working for the benefit of S. The court concluded an agreement having this effect is clearly unconscionable and incompatible with the public interest, and therefore contrary to public policy. There was clearly another public interest implicated in Susman besides exceptional unfairness. The contract degraded B to the position of a virtual slave working for the benefit of another and deprived B of the benefit of his earnings. But the existence of another public interest was never expressly required in this decision, nor in any other decision in which the Susman principle was later applied. The High Court in Standard Bank of SA Limited versus Wilkinson pointed out that the commercial life of the community is the setting against which the validity of contracts should be judged when applying the Susman principle. The court repeated the warning of the Susman case as follows. A court will not declare a contract or one of its clauses contrary to public policy unless it is so clearly inimical to the interests of the community as a whole, having regard to the morals of the times that the harm to the public is substantially incontestable. Ever since Afrox Healthcare BPK versus Strydom, the Supreme Court of Appeal has held that unequal bargaining power between the parties during the conclusion of the contract is a factor in consideration of public policy. In Barkhuizen versus Napier, a time limitation clause in a short-term insurance policy released the insurer from liability if the insured failed to serve summons on the insurer within 90 days after the insurer repudiated a claim submitted under the insurance policy. It was argued that such a clause limits the rights of the insured to seek legal redress. The Constitutional Court found that this right is not only a constitutional right as per Section 34 of the Constitution, but also constitutes a public interest. A time limitation clause could be so short that it amounts to an outright denial of the right to seek judicial redress, and such a clause would be invalid. The reasonableness of the time period must also be assessed with reference to the circumstances of the parties. Unequal bargaining power and a lack of understanding of what is being agreed to are indications of the unfairness of a clause, but they were not relevant in this case. The court concluded that the provision under scrutiny was valid and not against public policy, as the time period it gave the insured to exercise his right to the assistance of a court was not so unreasonable that its unfairness was manifest. Further, on the decision of the court accepted that, as the law currently stands, good faith is not a self-standing rule, but an underlying value that is given expression through existing rules of law. The Supreme Court of Appeal observed in no fewer than 3 cases that the fairness or unfairness of the time limitation clause was determined in the Barkhuizen case by investigating whether it restricted, but did not exclude, the constitutional right, the public interest, to have a legal dispute resolved by the courts. Fairness alone cannot determine whether a contract is contrary to public policy, and another more concrete indication of public interest is required than mere justice between the parties. The Supreme Court of Appeal stated in African Dawn Property Finance 2, Proprietary Limited versus Dreams Travel and Tours, CC, nor does the fact that a term is unfair or that it may operate harshly of itself lead to the conclusion that it offends against constitutional principles. These decisions of the Supreme Court of Appeal did not expressly qualify this court's limitation of Barkhuizen with the recognition of that excessive unfairness of a contract or contractual clause could be against public policy. The Susfin principle. Some High Court cases and commentators hold a contrary view, that it has been decided in Barkhuizen that the courts do not have a general equitable discretion to strike down contracts on the basis of unfairness. This view could conceivably prevail after the Constitutional Court decision in Botha v. Rich N.O., but the latter decision is also far from clear. These apparently contradictory approaches to the issue of unfairness by the Supreme Court of Appeal and the Constitutional Court create not only legally but also commercial uncertainty. And then there's a small pause for reflection. The law may limit contractual freedom when parties are in unequal bargaining positions. Our courts do not have a general equitable jurisdiction to strike down unfair contracts in the interests of contractual justice, nor do courts generally make contracts for the parties. Contract law recognizes the autonomy of parties to regulate their own affairs, and for that reason requires them to take responsibility for their decisions, including possible disadvantages resulting from exercising their freedom of contracts, by concluding a bad bargain, for instance. However, the parties are not held responsible for all consequences of their contracts, as the law often protects the parties. Parties are often in unequal bargaining positions for various reasons, such as illiteracy, poor language skills, poverty, and monopolistic trade practices. We thus find that contractual freedom is balanced by the intervention of the law to protect weaker parties in deserving instances. The purpose of many rules of the law of contract is to protect the weaker party. Good examples are the principles that serve to redress improperly obtained consensus. Public policy fulfills a similar role. Unequal bargaining power has been recognized in this regard as a factor when considering public policy. The legislature has also intervened for the protection of the weaker party. Prime examples are the National Credit Act and the Consumer Protection Act. Some commentators are urging the further development of the requirements of legality by recognizing a doctrine of unconscionability, as in other legal systems. A contract would be unconscionable if there is a marked disparity in the parties' bargaining positions and the stronger party abuses his or her dominant position. For example, where one party takes advantage of the other party's bargaining weakness by imposing onerous terms on the other party. This suggestion would bring the common law in line with the provisions of the Consumer Protection Act, but there would be a partial overlap with the principles that already serve to redress improperly obtained consensus. It might be prudent to further develop the existing grounds of improperly obtained consensus and to recognize new grounds as the need arises. Illegality, however, allows individual clauses to be attacked without voiding the whole contract. That's the end of the pause for reflection. In contrast to the uncertainty regarding the role of unfairness in the common law as set out above, the legislator has granted the courts an equitable jurisdiction in the Consumer Protection Act within the ambit of its application. Section 48, subsection 1a, prohibits a supplier from offering goods or services at an unreasonable price or in terms that are unfair, unjust, and unreasonable. Section 48, subsection 2, then gives specific examples of prohibited agreements and terms. Number 1. The contract is excessively one-sided in favor of the party other than the consumer. Secondly, the contract is so adverse to the consumer as to be inequitable. Number 3. A term is unfair, unreasonable, unjust, or unconscionable, and lastly, the attention of the consumer has not been drawn to the fact, nature, or effect of certain terms of the contract. A court may take the following factors into account to determine whether the contract is in a whole or in part unconscionable, unjust, unfair, or unreasonable. Number 1. Circumstances of the contract that existed or were reasonably foreseeable at the time the conduct occurred or the contract was concluded. Number 2. The conduct of the parties respectively. Number 3. Whether the consumer had to do anything that was not reasonably necessary for the legitimate interest of the supplier as a result of the conduct of the supplier. Number 4. The fair value of the goods or services. Number 5. The amount for which and circumstances under which the consumer could get identical goods or services from a different supplier. Number 6. Whether the goods were manufactured. Number 7. The nature of the parties, their relationship, and their relative capacity, education, experience, sophistication, and bargaining position. Number 8. Whether there was any negotiation between the parties and the extent thereof. And number 9. The extent to which a document complies with the requirements that information has to be in plain and understandable language. And number 10. Whether the consumer knew or ought to know of the existence and extent of the provision that is alleged to be unconscionable, unjust, unreasonable, or unfair, having regard to any custom and trade and previous dealings between the parties. If a court finds that a contract is unconscionable, unjust, unreasonable, or unfair, it may order that the money or goods be restored to the consumer or that the consumer be compensated for his or her losses or expenses relating to contract or court proceedings. Number 7.2.3.5. Unfair enforcement of a contract. The courts have recently accepted in principle that the unfair enforcement of a contract could be contrary to public policy. In Brisley v. Drotsky, the Supreme Court of Appeal assumed, without further consideration, that the Susfin principle could be extended to the enforcement of contractual terms. The parties had concluded an oral agreement contrary to a non-variation clause in a lease agreement. The lessee was late in payment of the rent in reliance on the oral agreement, but after accepting late payment for 5 months, the lessor cancelled the lease. The court found that the lessee's case fell far short from the requirement of exceptional unfairness. The purpose of a non-variation clause was to avoid disputes over the existence of later oral agreements. The unfairness of the enforcement of the non-variation clause related to the existence of the oral agreement, and thus the very purpose of this clause would be defeated if the defense of unfairness was upheld. Furthermore, the mere fact that a number of late payments had been accepted did not leave the lessee worse off, as the contract could have been cancelled upon the first late payment. Clearly, no specific public interest was infringed. The Constitutional Court held in Barkhuizen v. Napier that the enforcement of a clause would be invalid if the enforcement was so unfair or unreasonable in the circumstances that its enforcement was contrary to public policy. This would have been the case if the time limitation clause in question did not afford one party a reasonable and fair opportunity to approach a court to enforce his or her rights. Simple justice between the contracting parties must be done. The onus of proof rests on the party seeking to avoid the enforcement of such a clause. The court will have regard to all the circumstances of the case and in particular to the reasons for non-compliance with the clause. No facts were placed before the court in this regard, but the court suggested in an obiter dictum that the enforcement of a time limitation clause would be against public policy if non-compliance was due to impossibility, and furthermore that the principle of good faith could be used to determine when enforcement would be unfair or unreasonable. In two subsequent decisions, the Supreme Court of Appeal expressly rejected the interpretation of Barkhuizen as being authority for the view that fairness is a freestanding requirement for the exercise of a contractual right. Nevertheless, the court inquired in both cases whether the cancellation of the contracts was unreasonable and unfair, and found that the facts of each case that it was not. In Bredenkamp v. Standard Bank of South Africa Limited, the court pointed out that fairness must be considered from both parties' point of view. In Mapangu v. Angus Lifestyle Properties, the court reasoned. The respondent's business venture to acquire and upgrade residential buildings in the inner city of Johannesburg is commendable. Among other things, it appears to be in line with the initiatives of the Johannesburg City Council. However, since the respondent is not a charitable organization, it cannot be blamed for its unwillingness to pursue its commendable business venture at a loss, as would be the result if the current leases were to be maintained at agreed rentals. The respondent therefore decided to terminate the leases, as was contractually obliged to do, to save its business from commercial demise. In doing so, it behaved transparently by disclosing its motive, which it was not obliged to do. Had it not done so, the present litigation would probably not have ensued. Objectively, I can find nothing in the respondent's conduct that can justifiably be described as unreasonable and unfair. In Botha v. Rich, N.O., a trust sold immovable property to a closed corporation for 240,000 rand on monthly installments of 4,000 rand. The purchaser undertook to pay the municipal rates, taxes, and service fees. One of the clauses provided that if the purchaser breached the contract, the seller had the right to cancel the contract and the purchaser would forfeit all payments already made. In the event of the seller's cancellation, the purchaser conducted a laundry service on the property. The purchaser fell in arrears after payment of about 180,000 rand. No further monthly payments were made except one. The trust obtained an order of cancellation and eviction in the magistrate's court, but abandoned this judgment. The purchaser subsequently claimed transfer of the property against registration of a mortgage bond in terms of Section 27, subsection 1 of the Alienation of Land Act, but without offering to pay the arrear installments, municipal rates, taxes, and service fees. The seller again notified the purchaser of its breach and demanded rectification thereof. The purchaser only then tendered payment of the outstanding amount on fulfillment of the purchaser's claim in terms of Section 27. The seller ignored this offer and successfully applied for an order cancelling the sale in the High Court. The Constitutional Court granted the purchaser's application for leave to appeal against this judgment because the chances of success were good for two reasons. Only the alternative reason that the cancellation was unfair and thus constitutionally non-compliant is relevant here. The court pointed out that the seller failed to offer to repay the installments already paid by the purchaser, and then held that granting cancellation, and therefore in this case forfeiture, in circumstances where 3/4 of the purchase price has already been paid, would be a disproportionate penalty for the breach. This decision can be criticized on two grounds. The correctness of the court's conclusion that the cancellation was unfair can firstly be questioned. The court failed to evaluate fairness, also from the point of view of the seller. The first question is whether it would be fair to expect the seller to accept the purchaser's tender to pay the arrear payments, taking into account the purchaser's conduct preceding the tender and the fact that the purchaser could have simply paid the arrear amounts with interest and consequently remedied its breach of contract. The court also failed to take the following into consideration in determining the consequences of the cancellation to the purchaser. The loss suffered by the seller because the purchaser never paid the outstanding amounts before cancellation. The value of the purchaser's occupation of the property, and the fact that the penalty was subject to reduction in terms of the Conventional Penalties Act. Secondly, the court did not explain the precise principle or principles that applied in determining the unfairness of the enforcement of the cancellation clause. The court did not discuss and evaluate the appellate division's decision in Susvin, the Supreme Court of Appeal's interpretation of the Barkhuizen case, and even its own decision in Barkhuizen. This failure of the Constitutional Court to give clear direction in this regard potentially creates legal and commercial uncertainty. Moreover, it could easily lead to each judge deciding the issue according to his or her own ideas of what is unreasonable and unfair. Okay, and then there's a pause for reflection. The limits of a defense of unfair enforcement have not been defined. The Constitutional Court has recognized in principle the possibility of a defense of unfair or unreasonable enforcement of a contract, but has failed to define the limits of this defense. This will be no easy task. Three possibilities present themselves. Number 1. The formulation of the defense in Barkhuizen is very similar to the exceptio duelli generalis, and the guidelines developed in the case on the exceptio duelli could be used to develop the defense that enforcement of a contract is unfair in the circumstances. The exceptio duelli was initially viewed in a number of cases as an equitable defense against a claim for contractual performance, even when there was something unconscionable about the enforcement of the contract, but it was rejected in Bank of Lisbon and South Africa Limited versus de Ornelas. The Appellate Division found that this defense from Roman law was never received into Roman Dutch law and this could not form part of South African law. The chances are very slim that Barkhuizen could lead to a revival of the exceptio duelli due to its history. The Supreme Court of Appeal has now expressly rejected the interpretation of Barkhuizen as reviving the exceptio duelli. Number 2. The Constitutional Court placed the defense of unfair enforcement within the boundaries of public policy. A similar defense is already recognized with regard to restraint of trade clauses, which have a well-established test of unreasonableness. The obiter dictum in Barkhuizen with regard to impossibility and good faith seems to indicate that the rules applicable to unfair enforcement will not be similar to those related to restraint of trade clauses. And number 3. The Supreme Court of Appeal decisions decided after the Barkhuizen decision indicate that unfairness alone is not enough to make the enforcement of a contract against public policy. The unfairness should unreasonably limit some constitutional rights or other public interest. This approach must be qualified with the Susvin principle. The Susvin principle regarding unfairness is fairly well established, and it has been shown by the Supreme Court, albeit reluctantly, that it could be applied to the enforcement of contracts. The rules regarding this principle are well known and could be modified and further developed to deal with unfair enforcement. This possible solution has the advantage that it will not endanger contractual and commercial certainty and rests on established authority in the positive law. Although a commentator has regarded the decision in the Constitutional Court in Botha as exactly in line with the Susvin principle, the Constitutional Court did not refer to or apply the Susvin principle in either Barkhuizen or Botha. Number 7.2.4. The consequences of a contract that is void for illegality. It is an absolute rule that an illegal contract cannot be enforced. However, where the illegality only affects a part of a contract, that part can be severed from the rest of the contract in certain circumstances. If one or both have performed in terms of that void contract, such performance cannot be claimed back where the parties are equally guilty, unless the court specially allows them to. The consequences that flow from contracts that are void for illegality are discussed in some detail below. Number 7.2.4.1. Contracts cannot be enforced. Ex turpi rule. An illegal contract is void or invalid since one of the requirements for a valid contract is absent. An illegal contract creates no obligations and consequently it cannot be enforced. Neither party can institute action on the contract or claim performance from the other party because from an illegal cause no action arises. Ex turpi causa non oritur actio, known as the ex turpi rule. So, for instance, if a party has suffered damage as a result of such a contract, he or she may not claim contractual damages from the other party. A court does not have the discretion to relax this rule, and there are no exceptions to it. Performance by one or even both the parties to the illegal contract does not make the contract legal. Number 7.2.4.2. Severing the illegal part of a contract. A contract is sometimes only partially illegal. The courts have, in certain cases, allowed the illegal part of a contract to be severed from the rest, thus permitting the remainder of the contract to remain in force. In some instances, the courts have refused to do so, even where severance is possible because public policy requires the whole contract to be void. Whether the illegal part is severable from the rest of the agreement depends on the probable intention of the parties as it appears in or can be inferred from the terms of the contract as a whole. The courts have developed 3 guidelines to help them determine the intention of parties. Number 1. Is the illegal part of the contract grammatically or notionally distinct from the rest of the agreement? This will be the case, for example, where the illegal part forms an independent clause in the contract, and where the illegal part can be deleted from a contract without rewriting it. Number 2. Is the illegal part subsidiary or collateral to the main purpose of the contract, so that, if it is eliminated, the substantive character of the contract remains unchanged? Severance should not affect the nature of the contract that the parties have concluded. And number 3, would the parties have entered into the contract without the illegal part? The courts regard this question as crucial. The parties sometimes expressly include a severability clause in their contract, but such a clause is not always decisive. In most cases, the courts determine the hypothetical intention of each party. A court will only find in favor of severability if the answers to all 3 questions are in the affirmative. Number 7.2.4.3. Reclaiming performance that has been made in terms of an illegal contract, the par delictum rule. If a contract is void and there has been performance, restitution of what has been performed should in principle be granted. Where ownership of the performance has not passed, the performance can be reclaimed with a re vindicatio, the action of the owner for the return of his or her property. For example, the return of leased property, where occupation has been given to the lessee. If ownership did pass, the claim for the return of the performance will be based on unjustified enrichment. For example, a claim for the repayment of the rental that has already been paid to the lessor. However, the par delictum rule in pari delictio potior est conditio possidentis, where two parties are equally morally guilty, the one who is in possession is in the stronger position, will prevent restitution from taking place. This rule does not preclude the enforcement of an unlawful contract by means of a claim for specific performance. That is the function of the ex turpi rule, but it does prevent a party from reclaiming his or her performance in terms of an unlawful contract. The par delictum rule is based on two considerations of public policy. A court will not assist those who approach it with unclean hands, and unlawful contracts should be discouraged. The par delictum rule only applies where the parties are equally guilty in concluding an illegal contract or agreement. Accordingly, the rule will not apply where the plaintiff is less guilty than the defendant or is not morally guilty at all. A plaintiff's guilt is diminished, for example, where he or she did not know of the illegality of the contract or is reclaiming money paid to a blackmailer. An example where the plaintiff was not guilty is Minister of Justice versus Van Heerden. The court held that the state could recover diamonds that had been sold in an illicit diamond transaction designed to trap the defendant, an illicit diamond buyer. In other words, the par delictum rule did not apply. However, the Supreme Court of Appeal regarded the par delictum rule as applicable in Clocow versus Sullivan. The purchaser reclaimed his performance in terms of an invalid sale of a liquor licensed business. The contract was contrary to the requirements of the Liquor Act and invalid. He argued that the par delictum rule did not affect him as the act only criminalized the conduct of the seller and not also that of the purchaser. The court rejected this argument. The fact that the plaintiff was not criminally liable was irrelevant with regard to the question of his moral guilt or turpitude. The par delictum rule may sometimes operate very harshly towards a party who claims the return of his or her performance. Consequently, in Jashbay versus Qasim, the appellate division held that this rule may be relaxed in appropriate circumstances in order to do justice between the parties. The underlying principle of the par delictum rule is public policy, but public policy also demands that justice shall be done between man and man. The court considered the facts of the case. A sublessor applied for the ejectment of a subleasee on the ground that the sublease was illegal. Both parties were criminal offenders by being parties to the sublease. The sublessor did not terminate the lease with a month's notice as provided for in the illegal contract, while the subleasee complied with his obligations under the lease. Neither party was enriched at the expense of the other party. The court subsequently refused to relax the rule. This decision has been criticized because it is practically impossible to predict whether a court will be prepared to relax the par delictum rule in a particular case. It will depend entirely on the facts. The courts considered the following factors when deciding the question whether the par delictum rule should be relaxed. Number 1. Whether the defendant will be enriched at the expense of the plaintiff if the rule is not relaxed. And number 2, whether relaxing the rule would indirectly enforce the illegal contract. And lastly, any other consideration of public policy. In Clocow versus Sullivan, the contract of sale of a business was illegal for lack of compliance with statutory requirements regarding the sale of a liquor licensed business. The purchaser paid 250,000 rand of the purchase price and took possession of the business. The purchaser later returned the business and claimed repayment of the 250,000 rand. The Supreme Court of Appeal relaxed the par delictum rule as the equities clearly favored the purchaser. The seller was left with both the business and 250,000 rand. The only factor that the court considered was that if the par delictum rule was not relaxed, the defendant would have been enriched at the expense of the plaintiff. Number 7.3. Illegal contracts that are valid but unenforceable. Some contracts are against public policy, but this does not result in their invalidity. They are merely unenforceable in a court of law. A party to such a contract may not institute an action on the contract, but the ordinary consequences of unlawfulness, invalidity, as discussed above, do not apply. Such a contract may be validly performed, but the party who has performed may not claim restitution of his or her performance. Certain wagering contracts and certain contracts in restraint of trade are prominent examples of valid but unenforceable illegal contracts. Although in both cases the contract is directly and indirectly unenforceable, the indirect enforcement of a wagering contract often arises, whereas such enforcement seldom, if ever, arises within the context of restraint of trade agreements. The reason is that a wagering contract is often the basis or causa for the conclusion of a further contract, such as a contract of loan, whereas contracts in restraint of trade are seldom the causa for further contracts. Enforcement of such a contract of loan amounts to an indirect enforcement of the wagering contract. And then there's a small pause for reflection. Why does the law attach different consequences to different illegal contracts? Some illegal contracts are void, while others are valid but unenforceable. The question of illegality often involves a balancing of competing and sometimes even conflicting public interests. The interests of society as a whole and of the parties as individuals are involved in this process of balancing. This distinction between the interests of society and those of individuals is not absolute, as there is an interrelationship between these interests. Individual interests that relate to personal freedom, for instance, are also interests of society. Then again, societal interests are often to the benefit of the individual. It would seem that the law regards a contract as valid but unenforceable when the law considers the contract to be primarily contrary to the interests of the individual. In contrast, when a contract is considered primarily to be against the interest of society, the contract is regarded as void. That's the end of the pause for reflection. Number 7.3.1. Wagering and gambling contracts. The distinction between wagering and gambling contracts is of little significance because our law does not attach any consequence to this distinction. A gambling contract is a specific form of wager that involves the outcome of a game of chance. The term wagering contract will thus be used to include both wagering and gambling contracts. Wagering contracts are not fully regulated by legislation, and the common law is thus still relevant. Legislation has to be interpreted against the backdrop of the common law. The presumption of interpretation is that the legislator intended to change the common law as little as possible. Number 7.3.1.1. The common law. In a wagering contract, both parties reciprocally promise each other the performance, usually money, depending on the result, determination, or occurrence of an uncertain situation or event, without an independent interest in the result, outcome, or occurrence of the situation or event. The absence of an independent interest determines the question whether a contract is a wagering contract or not. If a party has a financial or other legally recognized interest in the outcome of the contract, apart from the prize he or she is able to win if the result is favorable, the contract is not a wager, but some other type of contract. A few examples serve as illustration. The parties to an insurance contract have no intention to bet on the question whether the insured house will burn down, but rather intended to guard against just such a possibility. Insurance is intended as a method of protecting an interest of the person insured. Another example is where parents promise their daughter a motor car if she passes the examination. This will usually be a conditional donation because the parents have the independent interest to encourage their daughter to study. The existence of an independent interest can also render a wager entirely valid and enforceable. This will be the case where the wager depends completely on the outcome of a game of skill, in which at least one of the parties has such an interest. For example, where two snooker players both claim to be the best player, and the only way to determine who the best player is would be for them to play a game. If one of the players were to place a bet on such a game, it would probably be a valid wager. Wagering contracts are not illegal or immoral as such, but they are against the public interest and unenforceable. The reason is that they encourage wastefulness and prodigality, which have harmful consequences for the individual, his or her family, and society in general. A gambling debt can be validly discharged and ceded, but cannot be directly enforced by way of an action. It cannot even be enforced indirectly, such as by way of a claim of the novation of a gambling debt, or a claim on a check that was given as payment for a gambling debt. It is uncertain, however, whether a wagering debt is capable of being set off against other debts. A loan made by an outsider to any of the parties to a wager may be enforced because it does not amount to indirect enforcement of a gambling debt. The same applies to the enforcement of a loan by one of the parties to a wager to any other party at the time of settling up after the wager. The settling up process is not an integral part of the wager. However, a loan by one of the parties to the wager of to another party in order to enable the latter to continue with the wager cannot be enforced. Number 7.3.1.2, the National Gambling Act Number 7 of 2004. Section 16, subsection 1 of the National Gambling Act determines the consequences of debts arising from different categories of gambling activities. Number 1. Licensed gambling activities. The Act and the provincial legislation require licenses for certain gambling activities. A debt arising from such a gambling activity is fully enforceable in law if a valid license is in existence. Number 2. Unlicensed lawful gambling activities. Debts arising from lawful gambling activities that are not required to be licensed are only enforceable to the extent that they are enforceable in terms of the common law. Number 3. Unlawful gambling activities. Debts arising from unlawful gambling activities have been discussed above and are unenforceable because of the wagering contracts are probably void. And number 4. Gambling activities of minors or persons excluded from participating in gambling. The Act aims to protect vulnerable individuals, such as minors and people registered as excluded persons. A person can be prevented from engaging in any gambling activity if he or she is registered as an excluded person. Certain people or the person him or herself can affect such registration. The Act states that debts arising from the gambling activities of a minor or an excluded person are unenforceable. The reason seems to be that the wagering contract is void. There are two indications of such an intention by the legislature. Knowingly paying out winnings to vulnerable persons is prohibited as a crime, and winnings from unlawful gambling activities can be declared forfeit to the state. And lastly, informal bets. Section 16, subsection 1e states that informal bets are not enforceable in law. This section amends the common law in that it excludes the possibility of a wagering contract being valid and enforceable. All lawful informal bets are thus valid but unenforceable. And then there's just a table that you can study on your own time. And then we get to number 7.3.2, agreements in restraint of trade. Agreements in restraint of trade are characterized by the limitation of someone's freedom to carry on a profession, trade, or business. They are encountered frequently in the following contracts. Number 1. Contracts of employment, where the employee undertakes not to compete with his or her employer after he or she has left the employer's service. And number 2, sales of the goodwill of a business, where the seller agrees with the purchaser not to carry on a similar business in competition with the purchaser. And number 3, partnership agreements, where each of the partners undertake not to compete with the partnership after leaving it. The enforcement of a restraint brings two contractual values into play. Sanctity of contract, which considers the maintenance of agreements freely entered into, including limitations of future economic activity as paramount, and freedom of trade, which emphasizes the right of an individual to engage without restriction in economic activity. These conflicting interests have to be balanced when the enforcement of a restraint is considered. Initially, the courts gave preference to freedom of trade under influence of English law, the traditional approach, and consequently regarded all contracts in restraint of trade as being against public policy and therefore void, unless the party wishing to enforce the restraint could prove that the restraint was reasonable. However, in Magna Alloys and Research SA Proprietary Limited versus Ellis, the appellate division overturned this approach in favor of sanctity of contract. A contract in restraint of trade is now valid and enforceable unless the party wishing to escape the consequences of the agreement can prove that the restraint is contrary to public interest and thus unenforceable. The restraint denier consequently bears the onus of proving that the enforcement of the agreement is contrary to policy. The court also held that an agreement in restraint of trade is contrary to public policy is not void, but only unenforceable. Subsequently, in Reddy versus Siemens Telecommunications Proprietary Limited, the Supreme Court of Appeal limited the onus of proof to the facts and excluded the value judgment on the reasonableness of the restraint clauses. And then there's a counterpoint. Do constitutional values require another reversal of the onus? The possible reversal of the onus back to the position under the traditional approach has become a highly controversial issue. And in some instances, such an approach has received judicial sanction in the High Court. This notion is primarily motivated by the fact that freedom of trade is now entrenched as a constitutional value. Section 22 of the Constitution guarantees citizens the right to choose their trade, occupation, or profession freely. However, the view that the onus should be reversed fails to take into account that pacta sunt servanda is also a constitutional value. A reversal of the onus does not seem to be required by the Constitution when weighing up these two public interests, since both are constitutional values. Furthermore, the Constitutional Court in Barkhuizen versus Napier confirmed that the party alleging that the enforcement of a contractual term is unfair and unreasonable must prove it. The appellate division explained in Basson versus Chilwin that a restraint of trade is contrary to public policy if the consequent of the restraint is unreasonable. The reasonableness or otherwise of a restraint is decided by weighing the interests of the community on the one hand and the individual interests of the contracting parties on the other. In this regard, the interests of the community involve the competing values of sanctity of contract and freedom of trade. The interests of the contracting parties entail the interests that the restraint enforcer is trying to protect and the interests that the restraint denier has in freely participating in the commercial and professional world. A restraint that is reasonable as between the parties may nevertheless affect an element of public interest that does not relate to the parties. In Basson versus Chilwin, the court proceeded to formulate a test to determine whether an agreement in restraint of trade is reasonable. This test has proved authoritative. The court posed the following 4 questions. Number 1. Firstly, is there an interest of one party worthy of protection? Number 2. If so, then secondly, is that interest threatened by the conduct of the other party? And number 3, If that is further so, then thirdly, does such interest weigh up qualitatively and quantitatively against the interests of the other party to be economically active and productive? And number fourthly, is there another aspect of public policy having nothing to do with the relationship between the parties that requires that the restraint should either be maintained or rejected? And then you can just study that table on your own time. The first question of the Poisson test requires that the interest protected by the restraint of trade agreement should be worthy of protection. Lack of such an interest usually means the agreement is against public policy and thus unenforceable. Possible exceptions are where the parties have agreed to similar reciprocal restraints or where the party being restrained is directly compensated for agreeing to the restraint. There is no exhaustive list of protectable interests, but the court usually referred to proprietary interests in this regard. Goodwill, trade connections, and confidential information, trade secrets, are two generally recognized proprietary interests. Goodwill refers to the commercial reputation and trade connections of a business. A trade secret is information that is capable of application in trade or industry, that is useful, only known to a restricted number of people, that is not public knowledge, and of economic value. A capital investment in a joint business enterprise is not a protectable interest. The investment of time and money in the training of an employee is also not a protectable interest, and nor is a skill acquired by an employee in the course of developing his or her trade while working for the employer. An employer may never protect itself against the mere competition of its former employee, as the employer cannot protect itself against the inherent ability or general knowledge of the employee. The second question of the Poisson test inquires whether the protectable interest is threatened by the conduct of the other party. This will be the case when the interest is infringed, but the mere risk of infringement objectively assessed will suffice. This risk will, for example, exist when an employee breaches the restraint and takes up employment with a competitor of his or her former employer, in a position similar to the one he or she previously occupied, because loyalty will be to the new employer and the opportunity to disclose confidential information will arise. Another example of such a risk is if the relationship that an employee has with customers is of such a nature that when he or she leaves employment, the customers will be easily induced to follow him or her to a new business and to infringe the former employer's goodwill. He or she would of course have to be employed by a competitor of the former employer in a similar position working with customers. The third question of the Poisson test involves weighing up the protectable interests of the one party, the restraint enforcer, against the interests of the other party, restraint denier, to be economically active and productive. This question implies a further question. Does the restraint go further than necessary to protect the interest deserving protection? An agreement in restraint of trade may only restrict a party's freedom of trade with regard to area, time, and activities insofar as it is necessary to protect the other party's protectable interest. The question as to the reasonableness of a restraint depends on the facts of every case. The application of the requirement of reasonableness as between the parties can be illustrated with reference to a restraint of trade in protection of goodwill. A business draws its customers from a certain geographical area. A restraint will, firstly, only be reasonable if it restricts competition within that area. Secondly, a party's ability to draw customers away from a business usually only lasts a certain period of time, because the relationship that the restricted party had with the customers is later replaced by other relationships, and customers also change as time goes by. The restraint will, thirdly, be unreasonable if it prohibits all involvement with a competitor of the restraint enforcer. For example, restraining a person involved in sales to the public from becoming a bookkeeper in a competing business will not involve any possibility of the goodwill of the previous employer from being infringed, and will therefore be unreasonable. The parties own view as to the reasonableness of the restraint as stated in the restraint agreement itself, and the fact that the parties did not conclude the contract on an equal footing are not conclusive, but merely two further factors to be taken into account when deciding whether a restraint is reasonable as between the parties. The importance of the relative bargaining positions of the parties is further informed by the constitutional values of equality and dignity. A number of older cases have held that a court will more easily conclude that a restraint is reasonable if the parties were in positions of equal bargaining power when concluding their contract. The fourth question of the Basson test involves any further relevant aspect of public policy, other than the reasonableness or unreasonableness of the restraint as between the parties. The reasonableness of a restraint as between the parties is only an indication of whether it probably is against public policy or not. Another aspect of public policy may require that a reasonable restraint should not be enforceable, or that an unreasonable restraint should be enforceable. And then there's a counterpoint. Is there another policy consideration besides the reasonableness of a restraint? There are no examples in case law where another aspect of public policy besides reasonableness or unreasonableness as between the parties played a role in determining whether a restraint was against public policy or not. Commentators have suggested two examples of such restraints. The first is the restraint of a nuclear scientist, one that is unreasonable as between the parties, where it would be in the public interest not to have the scientist's knowledge disclosed to others. However, such a restraint also seems to be reasonable as between the parties because there is a predictable interest because here a predictable interest is threatened by the scientist, and that interest weighs more than the interest of the scientist to be economically active. The second is the reasonable restraint of a surgeon with such unique skills that enforcing the restraint would be against the public interest. Once again, however, such a restraint also seems to be unreasonable as between the parties, since skills are not predictable interests. In Magna Alloys and Research SA Proprietary Limited versus Ellis, it was held that the question whether a restraint is in conflict with the public interest is to be assessed with regard to the circumstances prevailing at the time when enforcement of the restraint is sought. Prior and subsequent circumstances may also be considered, such as the course of dealings between the parties or the probable effect of a prohibitory interdict. Furthermore, a reasonable restraint can be enforced for an indefinite time by way of an interdict on condition that the restricted party may approach the court for an amendment of the order should the position regarding the respective interests of the parties undergo a significant change. All these rules confirm that public policy has a potentially changing content. In Magna Alloys, the court also held that an agreement in restraint of trade may be enforced partially. The reasons for partial enforcement are that the requirements of public policy in restraint of trade cases relate directly to the effect of the court's order and not primarily to the terms on which the parties happen to have agreed, and the public interest requires partial enforcement in appropriate instances. The power of the court to allow partial enforcement is subject to certain limitations. Number 1. The party seeking partial enforcement must raise the issue and establish a basis for partial enforcement. The party who does not wish to be bound by the restraint still bears the onus of proving that partial enforcement is contrary to the public interest. Number 2. A court will not partially enforce an unreasonable restraint that requires a drastic recasting of its provisions to make it reasonable, that is, major plastic surgery. The question is whether partial enforcement will materially alter the contract. And lastly, there is no exhaustive list of factors that a court will take into account in determining whether partial enforcement is justified. Two relevant factors are whether the restraint clause was calculated to be unduly oppressive or designed to terrorize, and whether partial enforcement would operate harshly or unfairly towards the person bound by the restraint. PVL3702, Law of Contract, Chapter 8, Possibility and Certainty. Number 8.1, Possibility. Number 8.1.1, the general rule. Impossibility of performance prevents the creation of obligations. A contractual obligation must be possible to perform for it to be valid. The general rule is that impossibility of performance prevents the creation of obligations. The impossibilium nulla obligatio est, as the Romans put it. Contracts that are void due to non-compliance with this requirement include the sale of an object that has ceased to exist. For example, an original painting which had been destroyed at the time of conclusion of the contract, of an object that never existed, for example, a portion of land that is incapable of subdivision, or of an object that cannot be disposed of commercially. Parties can agree to do the impossible for a variety of reasons. It could be that they are joking or lack mental capacity. In these circumstances, the necessary intention to create binding obligations is absent. It is therefore not necessary to apply an independent requirement that performance must be possible. However, usually the parties who agreed to do the impossible have the intention to create obligations, but they labor under a common mistake as to the circumstances surrounding the conclusion of the contract. Such mistakes will sometimes render a contract void. It is because of the possibility requirement that the parties are absolved from liability in these circumstances. The possibility requirement relates to performance itself, and not to achieving some underlying purpose. This, if I buy a frame for my painting, but the painting has already been destroyed in a fire, it is impossible to fulfill the purpose of framing the picture. Nevertheless, this impossibility does not affect the validity of the sale of the frame. Payment can still take place and the frame can still be delivered. It is only the purpose of framing the picture that can no longer be achieved. A challenge to the contract on the ground of mistake would also fail, since the mistake is merely one of motive, or a non-material mistake. And then there's a pause for reflection. Does ought really imply can? A traditional justification for the possibility requirement is that ought implies can, or to put it in more legal terms, one ought not to be contractually obliged to something that cannot be done. It is obvious that a person cannot be compelled to do something that physically cannot be done. But does it follow as a matter of logic that such a person should be absolved from liability? Some legal systems hold the party who cannot perform due to impossibility liable for damages. These systems do not regard possibility of performance as a requirement for a valid contract. They merely acknowledge that impossibility excludes the remedy of specific performance of the obligation. Number 8.1.2, different types of impossibility. Not all types of impossibility prevent the creation of contractual obligations. To exclude the creation of contractual obligations, the impossibility has to be of a certain quality. It is also important to distinguish between impossibility that exists at the time of the conclusion of the contract and impossibility that arises subsequently. In this regard, the classifications set out below are important. Number 8.1.2.1, subjective and objective impossibility. To render performance impossible, it is not sufficient that a particular party cannot perform. That is, mere relative or subjective impossibility is not enough. The impossibility must be so serious that nobody can render the performance, that is, it must be absolute or objective impossibility. A typical example of mere subjective impossibility is where a party agrees to make a payment, but does not at the time of agreement have the money to do so, or agrees to deliver but does not have them in supply. This impossibility should not influence the creation of obligations. Contrast this with the examples at 8.1.1 above of the various objects that cannot be delivered. Here, nobody can perform, no matter how hard he or she tries. A mere subjective inability to receive or make use of a performance does not entitle a party to escape liability. This, if a person books an overseas tour but is unable to make use of the performance because he or she unknowingly does not qualify for a visa, the booking remains valid in terms of the common law. However, such a consumer may exercise a statutory right of cancellation in terms of Section 17 of the Consumer Protection Act. Such a consumer does not have to rely on the common law of initial or supervening impossibility to escape liability. Number 8.1.2.2 Factual and practical impossibility. To state in theory that no obligation arises in the case of an objective impossibility is a relatively simple matter, but to apply this test in practice can be difficult. Assume the parties enter into an agreement of sale of some plastic ducks, which they believe to be in a container on a freight ship. Unknown to them, the container fell into the sea the previous day. Unlike the case of the destroyed painting above, the subject matter of sale still exists at the time of the conclusion of the contract. Its performance is therefore not factually impossible. Through a major and costly feat of deep-sea exploration, the seller could still retrieve the ducks, but the cost of doing so would be utterly disproportionate to its value. In these circumstances, the law recognizes that performance may be practically or economically impossible, and hence that no obligation arises. However, the courts will not easily make such a determination. Number 8.1.2.3 Legal impossibility. As indicated in Chapter 7, it is also a requirement for the creation of a valid contract that performance should be lawful or legal. This raises a rather difficult question. If at the time of the conclusion of the contract it is legally impossible to render a performance, is the contract void due to non-compliance with the requirement of possibility or void due to non-compliance with the requirement of legality? Because the impossibility flows from the illegality, it appears preferable to state that the legality requirement has not been met. However, in Wilson v. Smith, as Wilson v. Smith indicates, the distinction can be subtle. In that case, it was not possible as a matter of law to subdivide the property. The performance promised by the seller was illegal, yet the case was dealt with as one of impossibility and not illegality. Consider another example. By law, dealing in human tissue is highly restricted. However, traditionally, agreements to perform things that cannot be traded are regarded as invalid due to non-compliance with the possibility requirement, and not the legality requirement. Similar problems have also arisen in cases of supervening impossibility of performance, that is, where the impossibility arises after the contract has been created, and it can be ascribed to some prohibition of law. The distinction between voidness for illegality and voidness for impossibility is relevant when reclaiming performances made in purported fulfillment of void contracts. In the case of voidness due to illegality, claims for restitution are governed by the par delictum rule, which bars such claims in certain cases where the parties are tainted by the illegality. This rule does not apply in cases of voidness due to impossibility. Number 8.1.2.4 Initial impossibility, supervening impossibility, and making performance impossible. This chapter is only concerned with initial impossibility, that is, when it is not possible to perform the contract at the time of its conclusion. When impossibility arises after conclusion of the contract, valid obligations arise, but the obligations could either terminate or continue to exist, depending on the cause of the impossibility. In the case of supervening impossibility, the obligations can no longer be performed because the performance has become objectively or absolutely impossible, after the contract has been concluded. For example, A rents his house to B, but it is destroyed in a fire after conclusion of the agreement. The obligations then terminate. The situation where performance is made impossible through the fault of a party is treated differently. If A, in the example above, deliberately set fire to the house, thereby rendering habitation impossible, the obligations do not terminate. A commits a breach of a valid contract and B can claim damages and/or cancel the contract. These matters will be dealt with in detail in Chapter 15 on the termination of obligations and in Chapter 12 on forms of breach of contract. And then you can study figure 8.1 on your own time. Number 8.1.3. Exceptional cases. Liability despite impossibility. Number 8.1.3.1. Contemplation of impossibility and the assumption of risk. The general rule that objective impossibility of performance precludes the creation of contractual obligations is not uniformly applied in South African law. In Wilson v. Smith, the parties entered into an agreement of sale of a portion of land. It transpired that, in terms of an ordinance, it was not possible to subdivide the land in the way the parties contemplated. Justice Cooper confirmed the general principle that no obligation can arise in cases of impossibility. However, he then recognized that it is not applied in all cases. In this regard, he pointed to earlier case law, which stated that we must look to the nature of the contract, the relation of the parties, the circumstances of the case, and the nature of the impossibility invoked by the defendant, to see whether that general rule ought, in the particular circumstances of the case, to be applied. But this very broad test is not particularly helpful, and according to Cooper, the test is really whether, when the parties entered into the contract, the possibility was contemplated by them that the event which rendered performance impossible might occur. For if the possibility was contemplated and no provision made in the contract against the event, the implication could be made that the claimant could not be relieved because the event did occur. However, on the facts, both parties contemplated that the contract would be capable of execution in the normal way. The exception, therefore, did not apply, and the contract was void in terms of the general rule. The test in Wilson v. Smith deals with a situation where both parties contemplated impossibility. But what would the position be if only one of the parties foresaw or should have foreseen impossibility? A party can suffer losses if expenditures were incurred in the belief that a valid contract has been concluded, but this did not happen because performance was impossible. Nothing in principle excludes awarding such a party a claim for delictual damages if the other party wrongfully and culpably, that is, intentionally or negligently, instilled disbelief. And then there's a small pause for reflection. Contemplation of impossibility and the assumption of risk. Why does an obligation arise if impossibility is contemplated? One explanation is that the parties assumed that the one party would bear the risk of impossibility. This justifies depriving such a party of the protection of the general rule. That's the end of the pause for reflection. Number 8.1.3.2. Warranty, guaranteeing performance. The concept of a warranty bears a variety of meanings. For present purposes, it is only necessary to point out that a term inserted in a contract in favor of one party to extend the liability of the other party beyond what it would normally be. A party who is concerned that the other party may escape liability on the ground that no obligation was created due to initial objective impossibility of performance could insist that the other party should warrant performance. If the warranty is agreed to, the obligation is created, even though performance is impossible. The party in breach of the warranty would then be liable to pay damages. As with all contractual terms, a warranty can be created expressly or tacitly. The facts of a famous German case illustrate how a tacit warranty can arise. In SS Tekla Bolen, the parties entered into an agreement of sale of 1,000 containers of new potatoes from the Canary Islands on board the SS Tekla Bolin at sea. In fact, only 106 containers were on the ship. No obligation to deliver the remaining 894 containers could arise because there were no such containers. Nonetheless, it was held that the seller tacitly warranted that there were 1,000 containers on board the ship. Due to a breach of this warranty, the seller was liable to pay the purchaser damages. Number 8.1.4. The consequences of impossibility. In accordance with the general rule, no obligation arises if performance is objectively impossible. There cannot be a claim for either performance or contractual damages based on breach. Anything given in purported fulfillment of the non-existent obligation has to be returned. This duty to return can be enforced with a claim based on the unjustified enrichment of the recipient. When contractual obligations are reciprocal, that is, when one performance is promised in exchange for another, the impossibility of performance of one obligation automatically means that there cannot be an obligation to render the counter-performance either. Thus, in the case of the destroyed painting, no obligation arises to deliver the painting, and there is no reciprocal obligation to pay the purchase price, even though payment is still physically possible. Where performance of the contractual obligations is only partially impossible at the time of agreement, the contract could be regarded as invalid in its entirety, or obligations could arise in respect of those performances that are still possible. The divisibility of the performances is important in determining which of these consequences ensue. In Stansfeld versus Kuhn, the purchaser was supposed to pay £500 for half acres of land. Due to proclamation of a road, only 0.471 acres could be transferred. The contract was not regarded as invalid in its totality. The remainder of the land could still be transferred, and the price was proportionately reduced to £471. Where performance is not divisible, the position is more complex. Depending on the circumstances, the contract could be invalid in its entirety, or there could be a proportional reduction of the counter performance. Number 8.2. Certainty. Number 8.2.1. The general rule. Uncertainty about what has to be performed prevents the creation of obligations. It is a general requirement for the creation of contractual obligations that their contents must be certain, or be capable of being rendered through mechanisms set out in the contract. And then there's a pause for reflection. Uncertainty in practice. Why does it matter from a practical perspective that the content of an obligation is uncertain if the parties can explain the meaning afterwards? While nothing prevents the parties from supplementing or varying their agreement to facilitate its implementation, the parties to the negotiations may no longer be around to provide explanations, or the rights under the contract may have been ceded to third parties. This can make it impossible for a court to know what obligations must be enforced. It is not the task of the courts to create obligations, although they do, of course, have some power to interpret the contract so that it is effective rather than invalid, and to read tacit terms into the agreement on the basis of the actual or presumed intention of the parties. That's the end of the pause for reflection, and then there's a counterpoint. Is there really a need for certainty to be treated as a separate requirement for contractual validity? It has been doubted whether there is any need for certainty as a requirement separate from consensus. Can there be a meeting of the minds if that which the parties are supposed to perform is not certain? Traditionally, South African textbooks regard certainty as a separate requirement, although they somewhat paradoxically also simultaneously require that the content of an offer must be certain in order to establish consensus through acceptance. We will regard certainty as a requirement separate from consensus. It is quite possible that the parties may subjectively be in agreement on what has to be performed, but that the contract would still be void due to uncertainty. For example, even though the parties may be in full agreement that the one should pay the other a reasonable purchase price, such as such a term is legally invalid due to uncertainty. It must be conceded, though, that if certainty is regarded as a requirement separate from consensus, it can at times be difficult to determine whether the invalidity arises because of non-compliance with the certainty requirement or because of lack of consensus. For example, if the parties leave blank spaces in a standard contract, is the contract void because they have not reached consensus on a material aspect, or is it void because it is not certain what has to be performed? And that's the end of the counterpoint. Number 8.2.2, the application of the certainty requirement. Some practical examples. It can be quite difficult to determine whether a contract is void due to uncertainty. Sometimes the uncertainty relates to the terms of the contract itself, and sometimes to the application of some standard or mechanism set out in the contract that should be used to determine what has to be performed. The following examples illustrate these problems of application. Number 8.2.2.1. The contract aimed at creating another contract, the pactum de contrahendo or agreement to agree. A contract to enter into further contract, that is, a pactum de contrahendo, can be invalid due to uncertainty. This if the parties' consensus is only provisional and subject to further variation depending on their future negotiations or the further advice of a party's attorney, the content of the contract is too uncertain to give rise to obligations. However, sometimes parties enter into contracts that envisage the creation of further contracts without falling foul of this general principle. It has been held that this would be the case, provided that the terms of the contract to be made in the future are agreed upon. Important examples of a valid pacta de contrahendo include the following. Number 1. Options and preference contracts. In the case of the option, the terms of the envisaged agreement are already set out in the substantive offer contained in the option. In the case of the contract that grants a preference, the mechanisms aimed at protecting the party enjoying the right create sufficient certainty not to render the contract a nullity. And number 2. Some agreements to negotiate in good faith. Parties sometimes enter into agreement to conduct negotiations at a later stage. At times, they further expressly state that these further negotiations have to be conducted in good faith, but it is unclear whether this qualification is really necessary, since it could hardly be intended that the negotiations be conducted in any other manner. In any event, the courts have recognized that an agreement to negotiate in good faith would not be void for uncertainty if it contains some form of a deadlock breaking mechanism that applies when the negotiations fail. An example of such a mechanism is provided in Southern Port Developments Proprietary Limited versus Transnet Limited. Here the parties agreed that if no agreement could be reached pursuant to good faith negotiations, the matter would be referred to arbitration for final determination. A further, rather more complex example is provided in Mokate versus Vodacom Limited. Here, a solvent company and an employee agreed to negotiate in good faith on the amount that the employee would be paid for a highly profitable idea to provide a certain solvent service, and they further agreed that if the negotiations failed, the company's CEO would determine the amount. The Constitutional Court accepted that this agreement contained a valid deadlock breaking mechanism, albeit that the CEO could not represent the company at the initial negotiations. However, this was quite an unusual deadlock breaking mechanism, given the close connection between the CEO and the company. It has been questioned whether a deadlock breaking mechanism should be essential for the validity of an agreement to negotiate in good faith. Seeds of doubt are sown in Everfresh Market Virginia Proprietary Limited versus ShopRite Checkers Proprietary Limited. Here, the Constitutional Court not only suggested that our common law may develop to recognize that parties could enter into agreements to negotiate, but also stated that where there is a contractual obligation to negotiate, it would be hardly imaginable that our constitutional values would not require that the negotiation must be done reasonably, with a view to reaching an agreement and in good faith. Crucially, the Constitutional Court did not require that such an agreement to negotiate necessarily had to include a deadlock breaking mechanism. However, the implications of these obiter dicta still have to be determined. In Makate, the Constitutional Court merely stated that this remains a grey area of our law. Parties sometimes conclude a Memorandum of Understanding, or MOU, that serves as an initial basic contract that encapsulates key obligations, but is supposed to be followed by a subsequent, more detailed contract, which either supplements or supersedes it. An MOU constitutes a binding contract as long as it is intended to be binding and its content is sufficiently certain, despite its brevity. Number 8.2.2.2 Vague language and gaps. A contractual term could be void for uncertainty due to the vague language in which it is couched. Generally, courts will try to interpret agreements in a manner that leads to validity rather than invalidity. South African law has adopted the Roman maxim ut res magis valid quam perit, which encapsulates this principle, and has further approved the following well-known dictum in the English case of W.N. Hillas and Co. Limited versus Arcos Limited. Either which way. The problem for a court of construction must always be so as to balance matters that without violation of essential principle, the dealings of men may as far as possible be treated as effective, and that the law may not incur the reproach of being the destroyer of bargains. The relevant principles relating to interpreting contracts, and especially the limitations that patrol evidence rule places on relying on extrinsic evidence, are set out in Chapter 11. The principle above can be illustrated in a few examples. In Levenstein versus Levenstein, the parties undertook that, in exchange for the transfer of a property and business, the recipient would maintain the transferor to the best of his ability during the remainder of her life. At first, it would appear that this phrase is hopelessly too vague to be enforced. Nonetheless, the court regarded the ability to pay as determinable as a matter of fact, and the term was not regarded as void for uncertainty. However, in Barreta versus Beretta, an agreement to pay off a substantial sum every year was regarded as too vague. The full amount had to be repaid. The law does not expect parties to set out exhaustively every aspect of their relationship in a contract. If parties leave certain gaps, the law simplifies matters by automatically creating certain rights and duties, unless the parties determine otherwise. For example, if the parties do not determine when and where performance will take place, certain default rules of the law of contract apply. Number 8.2.2.3 Contracts of indefinite duration. At times, parties may enter into contracts of indefinite duration, that is, without stipulating the expected duration. This naturally gives rise to uncertainty, but courts generally give effect to these contracts, seeking guidance from the actual or presumed intention of the parties. The following scenarios can be identified. Number 1. The parties intend that the contract will be in force until such time as it is terminated by reasonable notice. Such an intention could be reflected in an express or tacit term to this effect. For example, where parties have to form and maintain a close working relationship with regular contact and interaction between them. A court may find it more probable that a tacit term enabling termination by notice exists, as opposed to finding that it was intended that the agreement would endure in perpetuity. Number 2. The parties intend that the contract will only remain in force for a reasonable period and then terminate. Number 3. The parties intend that the agreement will endure forever. It must be noted, though, that certain agreements are legally incapable of enduring forever. For example, it is an essential feature of the contract of lease that a lessor only temporarily parts with the use and enjoyment of the thing. According to Regulation 44, subsection 3L of the Consumer Protection Act, a term is presumed to be unfair if it has the purpose or effect to enable a supplier to terminate an open-ended agreement without reasonable notice, except where the consumer committed a material breach of contract. Number 8.2.2.4. Contracts containing a mechanism whereby certainty can be obtained. South African law has adopted the well-known Roman maxim, id certum est quod certum redi potest. In other words, something is certain if it can be rendered certain. The mechanism for obtaining certainty must function independently of the subjective intention of the parties. This does not mean that one of the parties cannot be involved in in the further determination of the performances. But such a determination potentially has to be subject to an element of the objective control. The following examples are instructive. Number 1. Certainty is obtained with reference to a mechanism contained in the contract. In contracts to provide for repeated performances, for example, payment of rental or the supply of goods on a continuous basis, it may be necessary to provide for an increase in what has to be performed over time to account for changed circumstances, such as inflation. Instead of renegotiating the contract, the parties may simply incorporate an escalation clause into the contract, which provides for an automatic increase in the amount of performance over time. A simple example is a provision that rental will increase at 10% per year over 5 years. Number 2. Certainty is obtained with reference to an objectively determinable external standard or mechanism. In Shell SA Proprietary Limited versus Corbett, a contract that granted Shell a preference to sell petroleum products with reference to the latest price lists ruling at the time was regarded as valid. More difficult, though, is the position where the parties agree that performance should be at a reasonable price. South African law, rather paradoxically, accepts that one can enter into an agreement to render a service at a reasonable price, although it has traditionally disapproved of an agreement to sell something at a reasonable price, or to rent out at a reasonable rental. To confuse matters even further, the courts have held that tenants can agree to be liable for reasonable expenses. This fragmented approach has been criticized since it is not clear on what grounds these various forms of performance should be treated differently. Number 3. Certainty is obtained through a determination by a third party. A third party can determine what has to be performed as long as the third party is identifiable and exercises the discretion objectively and reasonably. The contract can of course determine what degree of latitude should be accorded to the third party in making the determination. If the determination is manifestly unjust, a court can adjust it, but there is no duty on the aggrieved party to accept the adjusted performance. Number 4. Certainty is obtained through a determination by one of the parties. Contracts at times provide a discretion or power to one of the parties to determine what has to be performed. A discretion to determine one's own performance or to perform only if one wishes to do so, the conditio si voluero, is invalid. However, it is clear since NBS Boland Limited versus Wynberg River Drive CC that a party can enjoy a discretion to determine what the other party has to perform. The general principle was formulated as follows: save perhaps where a party is given the power to fix his own prestation or to fix a purchase price or rental, a stipulation conferring upon a contractual party the right to determine a prestation is unobjectionable. In that case, a clause in a mortgage bond agreement that granted the holder of the mortgage bond, that is, the bank, the discretion to vary the rate of interest payable by the debtor was regarded as valid. On the facts, the discretion to increase the interest rate was indeed properly exercised. According to Section 15 of the Consumer Protection Act, a supplier may, in certain circumstances, be obliged to provide an estimate and obtain prior authorization from a consumer when providing repair or maintenance services. Regulation 44, subsection 3H to J further declares that certain terms that provide the supplier with the discretion to determine what must or may be performed are presumed to be unfair. These are terms that subsection H allow the supplier to increase the price agreed with the consumer when the agreement was concluded without giving the consumer the right to terminate the agreement. Subsection I enable the supplier to unilaterally alter the terms of the agreement, including the characteristics of the product or service. Subsection J give the supplier the right to determine whether the goods or services supplied are in conformity with the agreement. Counterpoint. Why should a party not enjoy a contractual discretion to determine a price or rental? It is not at all clear why, under South African law, in contrast to many other systems, a party traditionally cannot be granted the discretion to determine price or rental, or why a reasonable price or rental is not acceptable. This position was rightly criticized in the NBS Boland case referred to above. After all, it is permissible to allow a third party to fix the price or rental. The price or rental is as uncertain at the time of the conclusion of the contract as in the case where one of the parties has the right to determine its measure. After MBS Boland, it was decided in Indian Petroleum Limited versus Commandunak Proprietary Limited that a clause could validly give a lessee the right to vary the rental, but this right had to be exercised in an objectively reasonable manner in the context of the agreement between the parties. Number 8.2.3 The consequences of not meeting the certainty requirement. An obligation that does not meet the certainty requirement is invalid. If such an obligation is severable, that is, may be separated from the other obligations created by a contract, the other obligations could remain in force. The contract is then only partially invalid. If it is not possible to sever the offending obligation, the contract as a whole is void. This may prove to be rather unsatisfactory if the offending clause was supposed to protect only one of the parties, and that party wishes to uphold the contract. There is some support in the case law for granting that party, in whose favour the clause would have operated, the power to elect to abide by the contract. Transfers made in purported fulfillment of obligations that are void due to uncertainty are retained without legal ground. This means that these transfers can be reclaimed with remedies based on unjustified enrichment.